Welcome to Laws 13013, Legal Professional Conduct, Topic 5, Discipline. I'm Stephen Colbran. Topic 5 explores the disciplinary processes associated with breaches of ethical rules. Misconduct can arise under both statute and the common law. In this topic we will examine both categories as well as potential mitigating factors that may come into play. Topic 5 will also explore the structure and operation of the disciplinary systems governing lawyers in place in Queensland. After studying Module 5, you should be able to outline the current position and historical evolution of the power to discipline the legal profession in Queensland. You should be able to canvass the problems that arise in attempting to define standards of conduct, the breach of which will justify the exercise of disciplinary powers. I hope that you'll be able to critically evaluate the procedures which can be utilised to initiate disciplinary action. And finally, I want you to appreciate the nature of disciplinary proceedings generally. The required reading for this week is Isaiah Ross, Ethics in Law, Lawyers' Responsibility and Accountability in Australia, Chapter 7. Discipline applies to the entire profession. As to the reach and rationale of the law in this regard, have a look at the commentary on the Federal Court Judge or former Federal Court Judge Justice Marcus Einfeldt's speeding case by Isaiah Ross entitled Judge's Speeding Case Shines a Spotlight on Legal Ethics. Justice Einfeldt suffered a monumental fall from grace over the simple matter of a $77 speeding ticket. He told the Downing Centre local court in Sydney that another person had been driving his car when the offence was committed. Investigations by the media have shown that the person Einfeldt named in his evidence, namely Professor Teresa Brennan of Florida, had been dead for 3 years at the time of the offence. After pleading guilty to perjury and making a false statement with intent to pervert the course of justice, Justice Einfeldt was sentenced in 2009 to 3 years imprisonment. He was subsequently declared guilty of professional misconduct, and his name was removed from the roll of local solicitors. The case is the Council of New South Wales Bar Association and Einfeldt. 2009 New South Wales Court of Appeal 255. In March 2011 he was released from prison on parole. There are many standards that apply to lawyers in their professional capacity. A lawyer is, on and from admission, an officer of the Supreme Court. The grant of a local practicing certificate also has the same effect. Legal Profession Act 2007, Section 48. Complaints concerning a lawyer may be made or referred to the Legal Services Commissioner. If the Legal Services Commissioner, or for that matter the councils of either the Bar Association of Queensland or the Queensland Law Society, decide that a practitioner has a disciplinary case to answer, they can lodge an application with the Legal Services Commission. The Bar Association of Queensland and the Queensland Law Society also have internal disciplinary powers they may exercise. The Queensland Civil and Administrative Tribunal, or QCAT as it's known, on a complaint laid by the Legal Services Commissioner, may hear and determine a complaint made against a legal practitioner. At this stage you should read Chapter 4, Complaints and Discipline of the Legal Profession Act 2007 Queensland to gain an appreciation of the disciplinary processes. The disciplinary procedures are designed to protect the public rather than to penalise the practitioner. That's an important fundamental principle applicable to these procedures. The Supreme Court aims to ensure legal practitioners accredited by it remain fit and proper persons to be entrusted with the important duties and grave responsibilities which belonged to a legal practitioner. So said Lord Justice Lopez in the case of Re Ware, W-E-A-R-E, 1893, 2 Queen's Bench, 439 at page 448. The Supreme Court's continuing accreditation function lies as the basis of the protective nature of the disciplinary jurisdiction. Practitioners who are not fit and proper may be suspended or removed from the role. There are two main categories of misconduct: unsatisfactory professional conduct, which is at a lower level, and professional misconduct, which is at a much higher level. The Legal Profession Act 2007, Queensland, sets out these two kinds of breaches. Unsatisfactory professional conduct includes conduct of an Australian legal practitioner happening in connection with the practice of law that falls short of the standard of competence and diligence that a member of the public is entitled to expect of a reasonably competent Australian legal practitioner. That's the definition which appears in section 418 of the Legal Profession Act 2007 for unsatisfactory professional conduct. Professional misconduct, on the other hand, is unsatisfactory professional conduct of an Australian legal practitioner if the conduct involves a substantial or consistent failure to reach or keep a reasonable standard of competence and diligence, and conduct of an Australian legal practitioner, whether happening in connection with their practice of law or happening otherwise than in connection with the practice of law, that would, if established, justify finding that the practitioner is not a fit and proper person to engage in legal practice. So you can see there that it extends beyond their role as a practitioner to other areas of their life. Continuing with section 419, for finding that an Australian legal practitioner is not a fit and proper person to engage in legal practice as mentioned in the previous part of the definition, regard may be had to the suitability matters that would be considered if the practitioner were an applicant for admission to the legal profession under this Act, or for the grant or renewal of a local practicing certificate. So the factors that were outlined in relation to the previous week on admission are also relevant to this notion of professional misconduct. Unsatisfactory professional conduct and professional misconduct can lead to disciplinary action. This can involve a reprimand or referral to the Queensland Civil and Administrative Tribunal, QCAT. You must keep in mind that the primary purpose of the disciplinary action is to protect the public, to try and ensure that breaches do not occur again, and to correct the professional conduct that causes them. What about negligence and carelessness? There's a distinction drawn in the cases in relation to this area. The Tribunal and Superior Courts have determined that negligence is a form of unsatisfactory professional conduct or professional misconduct only when it goes beyond mere carelessness or mere negligence. For example, a legal practitioner who does not know that a contract for the sale of land must be stamped before it can be registered shows a lack of professional competence and diligence that can lead to disciplinary action. A practitioner might know that a contract needs to be stamped, but make a simple mistake when calculating the amount of stamp duty due. This probably would be mere negligence, and that would not be a breach of the Act leading to disciplinary action. The dividing line between mere negligence and misconduct of the Act, under the Act, however, is not very clear. Let's spend a little bit more time looking at professional misconduct. Acts or omissions amounting to professional misconduct at common law, so it can arise at common law, and to a lesser extent the statutory breaches that I mentioned a little bit earlier, usually involve a breach of fiduciary duty owed by the practitioner to their client. the relationship is one of scrupulous fairness and honesty in the conduct of the client's professional business entrusted to the care of the practitioner. Several rules are applicable from the Australian Solicitors Conduct Rules 2011. For example, Rule 3 says that there's a paramount duty to the court and to the administration of justice. And in Rule 4, solicitor should be acting in the best interests of the client, should display honesty, competency, diligence, integrity, and independence. Rule 5 concentrates on avoiding dishonesty and disreputable conduct. The Legal Profession Act 2007, sections 418 and 419, have an inclusive statutory definition for professional misconduct and unsatisfactory professional conduct, respectively. You should make sure that you read these provisions and the notes that I've written in relation to these very thoroughly. Unprofessional conduct. This is defined in the Legal Profession Act 2007 Queensland in section 418. The definition has three limbs. Firstly, conduct occurring in the course of practice limits the disciplinary sanction in a way not present in professional misconduct. Secondly, standards of competence and diligence are judged by the expectations of the public, most likely based on standards observed by legal practitioners competent in a relevant area of practice, who are able to determine what constitutes competent and diligent practice in that area. Thirdly, the definition is not exhaustive. The definition may not be limited merely to the relationship between the legal practitioner and the client. It can extend beyond that. So sections 418 and 419 are critical for you to understand, but also section 420, which sets out conduct capable of being unsatisfactory professional conduct or professional misconduct, depending on the seriousness of the events. Take the time to familiarise yourself with the examples provided in section 420. So how then do we go about distinguishing misconduct from unprofessional conduct? Examples of professional misconduct may include misappropriation of client funds, conflicts of interest, forgery and tax evasion. They're quite serious matters. Examples of unprofessional conduct would include cases of delay, neglect, or incompetence in dealing with clients' affairs, failing to supervise staff, overcharging, and having sexual relations with a client. I've outlined in the notes the various tests espoused in relation to the civil standard of proof required when considering these issues, and you should have a look at that. There's also the case of In Re a Practitioner of the Supreme Court, 1927, South Australian State Reports 58 at page 60. In that case, it was said, in relation to professional misconduct, that is anything done by the practitioner in the pursuit of his profession which would be reasonably regarded as disgraceful or dishonourable. Note those words, disgraceful or dishonourable, by his professional brethren of good repute and competency. Unprofessional conduct is not limited to conduct which is disgraceful or dishonourable, in the ordinary sense of those terms. It includes, we think, conduct which may reasonably be held to violate or fall short of, to a substantial degree, the standard of professional conduct observed or approved by members of the profession of good repute and competency. There are, however, mitigating factors that are taken into account when tribunals are considering the circumstances surrounding professional misconduct or unprofessional conduct. The mitigating factors include no record of prior disciplinary breaches, community and professional reputations, cooperation with disciplinary authorities, the willingness of the person to accept that the misconduct has been committed by them, the demeanour of the practitioner during the proceedings, and also mental illness or substance abuse connected to the misconduct. That, of course, is a double-edged sword because it may also indicate lack of ability to practice. And really this ground of substance abuse in particular is rarely accepted as a mitigating factor. And there's the case of the Legal Services Commissioner and Musgrave, 2000, New South Wales, ADT 124 at 125 in relation to those factors. It's also possible to be restored to the role after you've been struck off, although it is quite difficult to do so. The court must be satisfied on solid and substantial grounds on an application for restoration to the role that a former practitioner is fit to be readmitted. The case of Dawson and the Law Society of New South Wales, unreported Court of Appeal judgment of the 21st of December 1989, included a summary of 10 principles set out by President Kirby. I've included these in your notes and you should spend some time reading through them because they're quite a clear statement of the sorts of factors that are taken into account in restoration to the role. Now we'll turn to the structure and operation of the disciplinary systems. Central to this process is the Legal Services Commission. You'll recall that the Legal Services Commission is a lay observer whose powers include investigating complaints, referring complaints to the Queensland Law Society or to the Queensland Bar Association, monitoring the handling of complaints by investigating authorities upon request by complainants, and also the review and determination of complaints by the councils. The usual practice, however, is to refer a matter to the Queensland Law Society or the Queensland Bar Association for investigation. There are 5 main procedures associated with the disciplinary workflow, not all of which necessarily will apply to any given case. But the main areas are assessment, mediation, investigation, review, and prosecution. So I'll just repeat those. Assessment, mediation, investigation, review, and prosecution. And that's what we will now turn to. So you can see initially what happens in the disciplinary system in relation to assessment is that an inquiry will be received by the Legal Services Commissioner. Now this may be something that can be simply resolved informally, or perhaps some advice given as to whether there should be any further action. However, if the complaint is thought to have some substance, the Legal Services Commissioner will assess the complaint and will make a determination as to whether they think it's a consumer dispute, which will ultimately be referred to mediation, whether it's something that can be summarily dismissed, or is it something which involves the need for an investigation. That is an area where there's a complaint concerning conduct. These matters are usually referred to investigation. The Legal Services Commission itself can, on its own motion, commence an investigation, so it doesn't need to have a complaint from someone else. So that's the basis of assessment. Now, if in fact the matter is going to be resolved or is suitable to be resolved through mediation, what happens is that the Legal Profession Act 2007, Chapter 4, Part 4.5 outlines the procedures for the mediation of consumer disputes or hybrid disputes involving both a consumer dispute and an issue of unsatisfactory professional conduct or professional misconduct by the practitioner or legal practice employee. So there are set provisions there in relation to mediation, and hopefully the outcome of the mediation is a resolution that there's no further action required. But of course that is not always the case, and it may be referred back to investigation depending on the nature of the matter. So let's have a look at investigation. The Legal Profession Act 2007, Queensland, Chapter 4, Part 4.6 outlines the procedures for investigations. The extensive powers of the Council or the Commissioner when investigating the complaint are found in Section 443, and you should have a look at that provision because they're quite broad powers. The entity carrying out the investigation may require a full explanation in writing or personally within a stated reasonable time, and there are powers requiring appearance and also for the production of documents if necessary. Failure to comply with this can result in a 50 penalty unit fine, or in itself can amount to professional misconduct. There are protections against self-incrimination and the possibility of voiding a policy for professional indemnity insurance is taken into account. So investigations can be made by the Legal Services Commission itself, or it can be referred to the Queensland Law Society or the Bar Association of Queensland, which will then conduct the investigation and make a recommendation. Those recommendations are then returned to the Legal Services Commission. What happens then is that the Legal Services Commission decides what further action, if any, to take on the matter. There's really only two choices. You either dismiss the complaint or you initiate a prosecution. The Legal Profession Act 2007, Queensland, Chapter 4, Part 4.7 outlines the decision of the Commissioner once the investigation is complete. They can start a proceeding, as I said, before the disciplinary body under Section 447. That's the QCAT, essentially. They can dismiss the complaint under 448, but in either case a record must be kept of the decision and the reasons for that decision as required by Section 449 of the Legal Profession Act 2007. Assuming that a prosecution is launched, then the Legal Services Commissioner will file the disciplinary action in one of two forums, either in the Legal Practice Committee or in QCAT, the Queensland Civil and Administrative Tribunal. The Legal Profession Act 2007, Chapter 4, Part 4.9 outlines proceedings in the disciplinary body. The processes differ depending on whether the Legal Services Commission files the disciplinary application with the Legal Practice Committee or the committee, or in much more serious cases with the Queensland Civil and Administrative Tribunal, QCAT. Assuming the matter went to QCAT, at the conclusion of the hearing, QCAT may, upon being satisfied that the practitioner has engaged in unsatisfactory professional conduct or professional misconduct, make a number of orders which are set out in Section 456. These include quite stiff penalties such as the removal of the practitioner from the role, suspension or cancellation of practicing certificates, placing conditions on practicing certificates, public reprimands, orders preventing employment, fines and compensation orders, and all of these orders can be enforced under Section 457. The committee, on the other hand, may, upon being satisfied that the practitioner has engaged in unsatisfactory professional conduct or professional misconduct, may make orders noted in Section 458, namely a public reprimand, a penalty of not more than $10,000, compensation order, an order to refrain from doing something, a requirement for management of a legal practice, periodic inspections, requirements to seek advice, ancillary expense orders, and orders preventing employment. The orders are filed, whether it's come from the Legal Practice Committee or from QCAT, the orders are filed in the Supreme Court and notice is given to the parties under Section 459. In relation to cost orders, you should have a look at Section 462. And also I suggest that you look at the compensation orders which are set out in Part 410. It is possible to have an appeal. You can see that an appeal lies from QCAT to the Court of Appeal, and ultimately the file will then be closed. So that concludes Topic 5, Discipline. Next week we'll be looking at topic 6, duties of representation.